Good afternoon. Welcome to MICA's Lunch and Law. I'm Julie Ritzman, Vice President of Risk Management at MICA. Let me introduce to you our speaker for today. Our speaker is Mr. Stephen Owens, who is the president of the firm Epperson & Owens here in Salt Lake City. Mr. Owens served as president in 2009 and 2010 of the Utah State Bar. He clerked for Justice Richard Howe of the Utah Supreme Court and has spent 20 years defending clients, including healthcare practitioners, in civil and licensing actions in the Utah state and federal courts. He has earned an AV Preeminent, the highest rating by Martindale-Hubbell. He is named a legal elite in healthcare law by Utah Business Magazine from 2007 to present. Steve has successfully defended numerous jury trials, obtained 4 successful verdicts in 1 year alone. For 6 years, he served as an elected commissioner for the Utah State Bar. Steve was awarded the National Harry S. Truman Scholarship for his leadership and public service. He is a member of the Pi Beta Kappa and was a William H. Leary Scholar at the University of Utah Law School. He is a member of the Utah Defense Lawyers Association. And so, with that, let me turn it over to Mr. Owens.
Hi, thank you all for being here. We certainly value your time, and it's a pleasure to be with you. Thanks to Julie Ritzman and MICA for putting this together. MICA is a wonderful company that really stands by its doctors. For instance, I've never been present where a MICA doctor tried to be, a MICA insurer tried to influence the doctor on whether or not to try to settle a case and things like that. That's very unique, and it's a pleasure to be associated with MICA. I did promise 30 tips in 30 minutes, and we're going to technically start in about 1 minute, but let me go through a few cartoons here, and I'm controlling this PowerPoint that I hope works. So I look at New Yorker cartoons from the New Yorker magazine, which frequently deal with doctors and lawyers, which unfortunately we need each other. The doctor, this is a little cartoon, the doctor's lawyer will see you now. This might make some of you wince. Next one, I'm afraid you're retaining lawyers, painful. Next one, does it hurt when my attorney does this? So believe it or not, I quoted this New Yorker cartoon in a hearing where the plaintiff's lawyer was insisting to be present for an IME of his client while my expert IME doctor evaluated the patient, and the judge laughed at this cartoon and denied the plaintiff's motion, said there will be no lawyers in the exam room. And then one more cartoon, I think. First, admit no harm, and this actually goes to one of the issues we're about to talk about in just a minute, which deals with expressing sympathy or apology to a patient. I forget if I have an adverse reaction, do I call my doctor or my lawyer? Again, these are kind of painful, but nevertheless, it's part of life. Well, I applaud you for being in the medical profession. I have a lot of family members in the medical profession, and I love working with doctors. I'm going to hit these 30 topics now, 1 minute apiece. My little caveats up front, these are general advice. Obviously, for specific advice, you want to talk to your actual lawyer or MICA. And then what I'm about to say are, many of these are my opinions and not necessarily the positions of MICA. Third caveat is I understand Utah law very well, and recognizing many of you are in Arizona, I have a sense for some of the things in Arizona, but there might be slight differences, and I'll try to point those out for you. Okay, apologies to patients. Let me just tell you, this is kind of a new area in the last 10 years. Utah has a statute, for instance, that says in any civil action or arbitration proceeding related to an unanticipated outcome of medical care, any unsworn statement or conduct made to the patient by the defendant shall be inadmissible as evidence of an admission against interest. if you express apology, sympathy, commiseration, condolence, compassion, general sense of benevolence. And you're describing the sequence of events and the significance of events. So, in summary, you can go to a patient after a bad outcome, explain what happened, explain your sympathy, explain that you feel sorry. What you don't want to do, and what a Utah court said, is you can't say, "we messed up," which is a statement of fault. So say the facts, say the condolences, but and you can say what kind of resulted from what, but you should avoid actually just saying, you know, "we messed up." Okay, let's go to the next topic. Pre-litigation hearings. In Utah, this is not in Arizona, before a healthcare provider can be sued in court, the plaintiff, which they call a petitioner at this stage, has to go through a mandatory pre-litigation hearing. The panel is organized by the State Division of Occupational and Professional Licensing. It is made up of an attorney chairperson, a layperson from the community, and a specialist in each of the fields, such as a urologist or an orthopedic surgeon, that is being accused of negligence. So you go in, they're 1 to 2 hours long, there's no record kept, there's no right to cross-examination, it's very informal, hearsay's permitted, and the panel essentially says we think it has merit or we think it has no merit. The only teeth in the statute in Utah is if you have merit, you can proceed to file a court complaint. If there's found to be no merit, you can still file a formal court complaint, but you first must produce an affidavit of merit by a competent medical expert. All right, next topic. Statutes of limitations are similar in both Utah and Arizona. This drives some clients crazy because it's a 2-year statute, but it's from discovery or notice of the alleged negligence, and so which can be a big loophole. And then the other big loophole is for minors, so kids, until they turn 18, the 2 years does not commence starting. So some things are obvious. Someone, complication of surgery, someone dies, that generally will put someone on notice that the 2-year clock is starting for them to file. But some are less messy, are more messy. So, for example, a sponge is left in a patient for 12 years and they don't discover it. The statute won't start till then. And a middle of the road case would be someone has, let's say, bowel surgery and their system is they're not digesting food well, but it's not till 4 years later that they go to a doctor and the doctor says, "I think this relates back to your surgery 4 years ago." That would be a grayer area. So that can be quite frustrating if you're a doctor and you want some finality. Okay, next topic. Tolling agreements. You may never have heard of these. Plaintiffs' lawyers don't like to get burned on the statute of limitations. Let's say they're unhappy with the surgeon, but they don't want down the road a finger to be pointed to the hospital, the anesthesiologist, and let's say the post-operative, post-discharge nursing home. What the plaintiff's lawyer may say is, okay, I'm going to proceed against the surgeon, but because I don't want to get burned on the statute of limitations, I'm going to ask that we enter tolling agreements or freezing agreements for the non-defendant treating providers. And so what this document is, it's usually just 2 pages long. It says, you know, doctor doesn't want to get sued, plaintiff's lawyer doesn't want to sue doctor, plaintiff's lawyer doesn't want to get essentially screwed over on the statute of limitations, and we're going to freeze or extend the statute of limitations for, it can be a year, something like that, with the right that I can bring that doctor back in later if circumstances change, and they can be effective. Let's go to the next topic. This is just generally, I want you to know how lawyers think about cases. We talk about, was there a breach of the standard of care? Standard of care is not the highest level of care. It's not perfection. It's a reasonable, prudent standard of what can be expected of a doctor in that specialty. Then we look at, if there was a breach, did it cause injury to the patient? And those things can often be quite disconnected. And then damages, talk about what actually damages were caused. We're talking about dollars usually here. So we try to defend cases on all standard of care, causation, and damages. However, sometimes we can't. So on one case I defended, the surgeon decided to give Lovenox after because they were worried about a heart problem. The Lovenox unfortunately bled into the spine and the guy became a paraplegic. I asked 3 different doctors to look into whether we could defend the causation issue of that case, and they all came back and said, no, the Lovenox thinned the blood that caused the bleed into the spine, which caused the paraplegia. And so we went and we actually fully went to trial on standard of care and won it on that, but we had no causation defense. All right, next topic. Mediations. Mediations are voluntary settlement conferences. Anyone can walk out anytime. Some cases, judges require them. Arizona has had a required mediation agreement requirement. However, I understand that they might be stepping away from that even this summer. MICA generally likes mediations if money's going to be offered. The idea is to jointly retain an experienced judge or retired lawyer, experienced retired lawyer or a veteran lawyer everyone respects. The parties pay that person equally. They have no dog in the fight, and they come in and evaluate the case. They're more than just people exchanging offers. I mean, they're actually weighing in. I don't think you're going to win on that, or the jury's going to really like your client, or this is a pitfall you may not see. And again, that they're voluntary. Anyone can leave, but they often, even if they're unsuccessful on the day of mediation, they often result in a settlement as a result of the mediation in the following weeks or months. Thank you. Next topic, arbitration agreements. You know, Utah had a big fight over these about 10, 15 years ago. And in the end of the day, I can tell you the end result was arbitration agreements do not favor doctors. We do far better in court than in arbitrations. Arbitrations are mandatory, non-trial efforts. Essentially, a mini trial is given to a panel of usually retired judges or veteran lawyers, and an agreement, essentially they make a ruling. The theory when these came out was these were going to save money and avoid big verdicts. But the sense is that they really, most of these panelists get known and they end up sort of splitting the baby. So Mike has never really endorsed arbitration agreements, and our firm certainly hasn't. The general thought is they might be helpful on a catastrophic case that is going to make all the jurors cry. But anyway, it's been a big thing to watch over the last 15 years, how they were embraced and then sort of rejected. Next topic, apportionment of fault to patients and non-parties. So both Arizona and Utah are comparative fault states. This means when a jury is evaluating things, they're saying, okay, did the doctor breach the standard of care? If so, did the doctor cause damages? Okay, then they might say, did the patient breach their duty to, for instance, call in if the situation changes? I'm thinking of like an ER doc discharges a patient, then the patient in the next 10 hours starts now developing shortness of breath, which the patient didn't have before. Should the patient have come back to the ER? Non-parties, an example of that would be a subsequent treating surgeon that is not being sued, but in the end of the day may have been involved. So the idea here is what courts don't like is this to be sprung on them at the last minute. So they say if you're going to apportion fault to people, we want it done up front or as soon as possible, and then the judge can decide if there's enough evidence to grant that apportionment of fault. So notice early is the watchword on that. Okay, next topic, non-party treating depositions. So if you're being deposed, you're a treating provider. Here's my advice to you. Stay within your care. Stay factual. Don't render opinions outside of your care. First of all, you're going to extend the deposition if you don't follow that advice. So maybe a 1 or 2 hour deposition could become a 3 or 4 hour deposition. Next, you could be drawn into the fight. So if two people are fighting with each other, if you think of the a gun shootout in the Western motif here, the last thing you want to do is stand up and raise your hands and draw attention to yourself. You want to kind of put your head down and do what you have to do, but nothing more. The next question is kind of related to it, being a retained expert. So in my book, no one should be a treating provider and a retained expert. A treating provider should maintain that role of talking about their own care, their own impressions, their own diagnosis, without rendering all kinds of opinions about everything else. But you're permitted to be a retained expert. I just would say it should be an independent person. You didn't treat the patient. Retained experts, should be paid and properly prepared, so you're given everything to look at, and then you can render opinions either on behalf of the defendant doctor, or maybe it's not even a malpractice case. Perhaps it's just an auto accident and they came in and now they're complaining of continued neck pain or something, and you're a neck expert and you're going to render opinions, maybe evaluate the patient, prepare a report, expect to be deposed. And it's an okay position to be in, but it's a very distinct position from being a treating provider. Okay, next topic, taking a cold call from a patient's lawyer. Here's the rule. You can do this. You can't take a call from a defense lawyer who's contrary to your patient if the patient is the plaintiff. So let's say you're sitting in your office, you get a call, hey, your patient, Mrs. Jones, is my client, I'm her lawyer, and I want to talk to you. So here's my advice. You don't have to do this, but my advice is, please send me a letter. I need to get my patient's okay, so you can't always trust what you're being told. And I would prefer just to maintain my independence as his treating provider. That way, you're not being drawn into the facts. Remember the distinction between treater on facts and now a retained expert who's drawn to one side or the other. And it really helps the patient's lawyer. They may not know that, but by you maintaining your independence, you're going to be given more credibility if you're ever deposed and things. And plus, you might be walking into sort of traps. It's just better to say I'll do what I need to do, but I don't want to do more. And if they're feeding you facts and things, I think it ends up being kind of a minefield that you should avoid. And again, Micah, you blame it on me or Micah and say, I have to advise my lawyer before doing that. When not to take the call, I just hinted at this, but in Utah, and I am sure this is the fact in Arizona too, you cannot talk to, if your patient is suing someone, you cannot talk to the other lawyer. It's an ethical violation. You don't have your patient's permission to talk to a lawyer adverse to your patient about your patient. So even scheduling a deposition, I would say work through my work through my assistant. You just don't want to be on a call with someone who's contrary to the interests of your patient, because they didn't allow you to do that, and you don't want to be misquoted later. And really, it's a problem, ethical problem for the lawyer as well, because they shouldn't be talking to a treating provider. They have no authority by the patient to talk to you. And so you don't want to get cross with your own patient. And then needless to say, you shouldn't become an expert against your own patient. So there's a case in Utah on that where the court really ripped the neurologist who was hired by the defense lawyer in an auto accident to testify contrary to the wishes of his own patient, and he got ripped. Okay, next topic, licensing complaints. Let's say you're in your office, busy patient day, and in comes an investigator from the State Division of Occupational and Professional Licensing and says, I would like your records now on this patient, and I'd like to interview you right now on this patient. Here is your response. I would love to cooperate. Thank you for giving me the opportunity to answer questions. Do you know, I would like you to work through my lawyer. Can I send you his or her name tomorrow? And we'll do this at a time that they can respond to your subpoena, and I can arrange this at a convenient time. The investigator should always say yes to that question. It's very reasonable. But what you don't want to do is try to haphazardly make a copy of a chart, haphazardly try to give answers to the investigator, and try to resolve this quick, because you want to slow it down, get your lawyer understanding what's going on, and there might be a much broader picture. Same advice really if you get a cold call from a DOPL investigator. That's MICA, by the way, has coverage through a separate company, NAS, to provide defense counsel fees to defend a licensing investigation, and you definitely should do that. Informed consent. I just had a conversation this morning about informed consent. A written informed consent is not required by law, but it sure makes life easier for you, because the patient can't later say, I didn't know nothing about nothing, which is what they always say. So you got a nice written consent form. Usually the language is to the effect that no guarantees have been made, my questions have been answered, I have alternatives, I've investigated, here are the lead, substantial significant risks of the procedure. You've seen them all. In Utah, if that document is in place, and I think Arizona has a similar statute, the burden shifts completely to the patient to prove that there was some funny business, that this excuses them from that document. Now, informed consent can be obtained without a written document. It's just harder to prove. And likewise, a written document doesn't give you informed consent. It offers proof of that, but in theory, it documents what should be a one-on-one conversation with the patient about the risks of what you're about to do and their consent to do it. So informed consent is not the written document, but in this day and age, you absolutely should have one. Next, consent to settlement. So MICA will not settle a case without your written consent. And good for them. If you get in an auto accident, State Farm might not even call you. Well, they may just settle the case without you. You're in the driver's seat on whether to consent or not. And, out of my last 10 trials, I'd say 8 of them were the doctor did not consent to settle. Now that means 2 of my trials where the doctor consented to settle and the case did not settle. So just because you authorize settlement does not mean MICA will settle the case, because if MICA believes the plaintiff's counsel is being unreasonable, we'll still go to trial. If there are excess exposure issues, so if you lose, it will be over $1 million, just speaking as someone interested in you, there's more of a consent discussion, because if you fail to consent and it's over $1 million, for instance, if that's your limit, you do face a potential personal exposure. So if it's a kind of a catastrophic case, there's a much broader consent to settlement discussion that should be had. Okay. Data bank concerns. So in this day and age, when doctors are discussing whether to settle or not, part of the thought process, this will be disclosed on a data bank. In Utah, there's a national practitioners data bank. It goes to a limited number of people. It's not publicly accessible, but it goes to hospitals where you're seeking privileges. It goes to licensing entities, and it goes to medical malpractice insurers. The other group that may ask for it are health insurance panels. All right, so the National Data Bank was set up so that there be a recording whenever MICA, for instance, makes a settlement on your behalf, it's recorded, and they have a federal regulation requiring a data bank report, which explains the amount, general facts, and circumstances. By the way, there are very few experienced doctors without some data bank entry, but that should be a part of your discussion with your defense lawyer. Disclosing pending claims to health insurers, hospitals, and licensing entities. So you got to be careful on this. In Utah, for a pre-litigation claim, for instance, you have not been sued. So if the question is, have you been sued? The answer is no, if it's just a pre-litigation claim. Or in Arizona, I'm sure there are some claims that they're trying to arrange a settlement before a lawsuit is filed. So you got to look at the exact wording of the question being asked. If it says claims of any kind, if you have any pending claims of any kind, then you have to say yes. But I usually put in things like, we believe it lacks merit. There are 4 other defendants. I'm not the lead defendant. We have supportive experts. We are actively defending the claim. Those are sort of things you can say. The pre-litigation hearing in Utah is actually privileged, but is considered confidential. But so are these credentialing documents and things. So I usually say that the pre-litigation hearing was in our favor, for instance, on these documents, and your defense lawyer again can help you with that. Next topic, caps on non-economic damages for living patients. This is a distinction in Utah versus Arizona. In Utah, there is a cap on non-economic damages. Non-economic damages are non-money pain and suffering damages, and that limit is $450,000 in Utah. In Arizona, there is no cap on that. In Utah, the juries are not advised of the cap. It's something, if the verdict is higher on that issue, then the court will reduce it. When I say living patients, that implies that it's different for deceased patients, and that's true. There's no cap even in Utah for non-economic damages for deceased patients. Next topic. Good Samaritan statutes. So both states have this. It says essentially, if a person who renders emergency care at or near the scene of or during an emergency gratuitously, means without being paid, and in good faith, is not liable for any civil damages or penalties as a result of any act or omission by the person rendering the emergency care. And sometimes there's absence, gross negligence, or kind of reckless behavior. So the classic example is you come upon a car accident. A less classic example is you're not an ER doc on call, but in a hospital you respond to a code overhead. The most recent case I've read is you're not an ER doc, you're not on call, you're not being paid, and you respond to a code. You can apply the Good Samaritan statute, which I think is interesting. The statute applies also for government, at the request of government entities in an emergency, like a natural disaster. I have a long story that I could tell you about a case I used that. Essentially, a chiropractor coming down at his daughter's basketball game where someone was injured and rendered care, and which turned out to be negligent care, and we won on the Good Samaritan statute. Okay, next topic. Higher standard of proof for emergency physicians. This is a trend in the last 5 years. So ER docs have been given a break by state legislators because it's a little different. They have no control over who walks in the door, and they have to treat everyone who walks in the door. And they were getting sued a lot. So the statute now says, whereas normal doctors, non-ER doctors, the burden of proof is preponderance of the evidence, or 50.1% of the evidence can establish as breach of care. For ER docs, it's a clear and convincing evidentiary burden, a higher burden, which favors ER docs. So you can't just prove it barely. You actually have to prove it more clearly against an ER doc, and that's just a policy decision that to kind of help ER docs, and I think in response to some real or perceived crisis that ER docs were getting sued unfairly too much. Next, contingency fees for plaintiff lawyers. There is a distinction between the states. In Utah, the plaintiff lawyer can only charge 1/3 plus costs of any settlement, judgment, or recovery. There is no such cap in Arizona. So sometimes those plaintiff lawyers get away with charging 40%, say, or 45%, and maybe even 50% of that. So, but that's limited in Utah. So when you're trying to talk a plaintiff lawyer out of bringing a lawsuit, or I should say when I am, I'm thinking about their contingency fee plus costs. What I need to show to them is that this is a fight they don't want to get into, because it's going to be a messy, long, expensive fight, and they're likely going to lose, and they're going to be really have to be quite invested. And so often when we're trying to talk a lawyer out of pursuing a claim, peer review quality improvement privilege is alive and well in both states. The idea is if you, let's say, nursing home fall, patient dies, okay, we're going to formalize this committee to get in. The director of nursing's coming, the medical director, and we're going to go through and really find out what happened, what could we do better, what should we have done better, that kind of thing. That's all privileged. And the policy is a good one. It's that we want doctors talking openly about how things can be improved. What doesn't count is a loose conversation in the hallway. Did you hear what happened to that patient? Man, we really botched it. You know, that nurse should not have given that drug. That wasn't ordered. And that kind of loose, informal talk outside of a formal quality committee meeting will not be covered by the privilege. So, and if you're ever preparing a document, not to go in the patient's file, but to go into the risk management file, you should clearly put at the top, you know, non-discoverable under the peer review quality improvement privilege. I mean, so it's not just non-admissible at trial, but literally it cannot be discovered by the plaintiff that it even existed. But you should mark that carefully and do it in a formal way, not an informal way. Next topic, independent medical exams. They no longer call these IMEs in Utah. They call them Rule 35 exams. So these are still permitted. If plaintiffs saying, like, as a result of my GYN surgery, I have all these neurological problems in my legs. Okay, we can arrange, I can file a motion if I have to. Often we can just cooperate. This doctor at this time is going to do it under these circumstances. Key to that is whatever that shows, both sides are going to get a copy of the report. And We frequently choose not to do independent medical exams because if we acknowledge, we don't want to acknowledge huge things and prove plaintiff's cases for them. Some you can't help it. Obviously, if I have a paraplegic, I need to be able to know how it, you know, like at what level of paresthesia, that kind of thing, and I may want an independent doctor. Often, though, we just go depose the treating providers and hold off on an IME because the defense is stuck with whatever the defense IME doctor says. Next topic, non-patient cause of action. This is a relatively new area of law, and believe it or not, I argued the case at the Utah Supreme Court. A doctor, a man murdered his wife, tragic. His kids sued the husband's healthcare provider, saying, you had him on all these mental health meds and that were a crazy combination, and send him into this roid rage that caused him to kill our mother. We got that dismissed at the trial level, but the Utah Supreme Court unfortunately decided that there could be circumstances where a doctor has a duty to a non-patient. So I know of another case where a dialysis center sent a patient home, and the patient drove home and crashed because they were too weak. And the person they crashed into sued the dialysis center. So this is a non-patient suing the healthcare provider of the patient. And in some of those circumstances, the courts are letting those go forward. In Utah, in response to my appellate case, the legislature actually says we're going to put in a reckless and indifferent standard of care, standard of evidence. So it's going to make, essentially it'll protect doctors more, but that's a new area of law. Parental loss of consortium claim is also a new area of law. So let's say a child has a birth injury and does not die. The parents have always been able to bring a claim on behalf of the child, but now in Utah at least, they can bring a loss of consortium claim, which I understand this actually to be the case in Arizona now too. They can say not only does we get to collect money for the child for all the care needs and loss of ability to enjoy life, but the loss of the parents' ability to enjoy their non-injured child. So the result of this is those kinds of claims could go up. The exposure of those could go up because this is now sort of a recognized area of the law. Next, damages. Utah actually has tiers that lawsuits are filed. If they're claim under $50,000, they're filed as tier 1 cases. If they're $50,000 to $300,000, they're filed as 2-tier cases. And if they're over $300,000, they're filed as tier 3 cases. The idea is smaller cases should have less discovery and should be on tighter time frames. Now, the reality is almost all cases are filed as tier 3, and so this doesn't have a big effect. Utah is much slower in the courts than is Arizona, so it's not uncommon from filing to conclusion of the case in Arizona for that to only take a year and a half. In Utah, with the pre-litigation process, which usually takes 6 months, and kind of slower deadlines, it's not uncommon for that to be 2.5 to 3 years. But that was, the tiers were sort of an effort to sort of speed along smaller cases. Going to trial is emotional, and there is an emotional component that I think may not be known. I mean, it's out of your comfort zone, even if you're big time doc doing brain surgery. Going into trial and having someone kind of beat up on you for a week on the stand it's a whole different feeling. So something to talk to your doctor about. I say, do you want to, sometimes I say, are you married? Yes. Let's talk about whether you want to invite your spouse to be present with you at trial. And I usually say, if it'll help you, my client, yes. If it won't, because you'll be too worried about your husband or wife back there worrying about you, then I don't want them there. Sometimes spouses come for opening arguments and closing arguments, but not during the evidence. Sometimes they never come, and sometimes they come all the time. But you just kind of got to be prepared to kind of be in a different arena. I mean, you'd much rather be on a beach in Hawaii, I'm sure. But I had one doctor burst into tears, even though we won. At the end of the verdict, he burst into tears because he just said this was emotionally draining. Not trying to scare you, I just want to let you know that it's a different type of feeling. Punitive damages are permitted. So classic examples of sort of reckless or intentional misconduct would be you're operating impaired. You're on, illegal substances or something. You are, groping a patient sexually, not good. Sex, drugs, and fraud get everyone in trouble. You're billing for non-necessary procedures. Those are examples. So a lot of plaintiffs' lawyers throw punitives in because they're trying to sort of adjust to get a bigger settlement. They're not insured, so they add that element. But most claims for punitive damages should not be in there. And I've found the better lawyers tend not to add them. They add sort of a different element to the case, and they make people mad, and they're usually not justified, and often we can get those dismissed pre-trial. Next, when damages could exceed policy limits. So there are times you should hire a personal lawyer. So this is separate from the MICA lawyer, and this is if your policy limits could be exceeded. So if I've had a lot of scenarios. One is I consent to settle, and the case settles within policy limits. Okay, that's no problem. I consent to settle, and the case does not settle within policy limits, but it could settle within policy limits. And if I lose it, it could exceed policy limits. This is a good time to hire a personal lawyer who can explain kind of your rights to protect you. Now, if you do not consent to settle and it could exceed policy limits, I think it's also a good time to talk to a personal lawyer. Your MICA appointed lawyer can advise you on these issues, but they can't get into disputes between you and MICA. So, and I'd say this happens like 1 in 1,000 cases. So this is not common, but where the personal lawyer can sort of be more assertive in requesting MICA to consent or take the exposure if there is to be exceeded limits. Anyway, that's just sort of an issue you should be aware of. I think I am at the end of my 30 minutes. I'm happy to take questions. There are a lot of other issues. It's a pleasure to be with you, and I'm grateful for having the career of being able to represent healthcare providers and work with you and MICA.
Thank
Julie?
you, Steve. Yep, this was a whirlwind. We're actually over the 30 minutes, but let's take a couple of questions really quick. And while we do that, I just want to note to mark your calendars for the next Lunch and Learn on Wednesday, March 21st. And we're actually going to be covering telemedicine or telehealth. So the first question, I am an orthopedic surgeon and on occasion will perform a knee replacement on one extremity and then a few weeks later perform a knee replacement on the patient's other knee. Do I have to go through the informed consent process for the second surgery since the patient already knows what the surgery involves?
And do you have to? No. Should you? Yes. Because there's a little different discussion after they've had another surgery that maybe perhaps hasn't healed all the way. On weight bearing, for instance, I have a case right now where first one ended up not healing because the second one, they put too much weight on the first one. So the answer is yes. You want a nice, clean consent form for the actual, each procedure that you're doing, rather than relying on a prior one.
That's what I would agree with that as well, that you want two separate consent forms. The second question is, I'm the manager of a family practice clinic, and we have patients who die unexpectedly periodically. Sometimes they are elderly, and my physicians want to send a sympathy card or flowers to the family. Sometimes they are young, and there is a GoFundMe account set up online, and they want to contribute. Are any of these things issues from a HIPAA perspective, or if there was an adverse event, how would I go about doing that? Or should I go about doing that?
If you want to do it, don't talk about the patient's care. You don't even have to say, I was his lawyer, I was his doctor, at this surgery. So if you want to do it, send flowers, contribute to GoFundMe, express sympathy, go ahead and do that. Just don't talk about your role or the facts, or certainly, as we learned from the admission thing, don't start admitting fault. So you don't have to say, explain your role and what you saw. Those would be HIPAA violations, but flowers, GoFundMe, I certainly have doctors who say, I went to the funeral. I mean, I was close to the family. No problem.
Okay. And the next question, and I think you kind of covered this, is recently a friend from medical school was hit with an excess verdict. Who is expected to pay when damages exceed policy limits? What if he doesn't have any capital or personal savings?
So you have to go back and kind of see what he was told and when, and I certainly wouldn't tell a doctor that he has no exposure on excess problems if it was a possibility. It's hard to retroactively say. I can tell you, MICA certainly, or any insurer, would want to protect the doctor's interests, and part of that is using the leverage of an appeal to try to negotiate down the excess amount to within policy limits. Negotiating directly with the plaintiff's lawyer, for instance, do you really want to try to go after him, his own personal assets, or you're not going to get anywhere on that? Let's try to settle for a lower amount. It's hard retroactively to kind of explain what would happen, but
sure, as each case is probably its own.
Yeah, and MICA's not just going to cut you loose and say you're on your own. I mean, they're going to work hard to try to get it settled within policy limits, and exercise appeal rights is a big part of that.
Okay, next question. Are you liable if after seeing a patient in the office, we request that they not drive home, but the patient chooses to do so and then is in an auto accident?
So patients, you can't control everything a patient does. People do leave ERs even against medical advice. It's nice to have a nice signed document, like, we're telling you not to do this, and you're telling us you're going to do this, and you're waiving any rights against us. Even if it's handwritten like that, I think it would be helpful. I don't know. I think of a bartender letting a drunk drive home. I mean, maybe we should be calling their emergency contact saying they're not making wise decisions, and would you please come help them? I don't know. That could be a HIPAA issue too. We can't make patients do things. I mean, we tell, for instance, nursing home patients, don't ring for the help if you need to go to the restroom, but sometimes they don't and they fall. I mean, so you do what's reasonable under the circumstances, and then that's what's expected of you. I don't know what you wouldn't call the police, for instance, to come arrest them. That would seem to be an unreasonable expectation.
So a lot of health systems that I've worked in the past will offer to give the patient a voucher for a taxi so that they can take the
That's
taxi home in
certainly
case
a
there's concerns about the
creative.
cost of a taxi.
That's a
Or even
creative, good idea.
or a token for a bus or whatever the case may be.
That's a good creative idea.
Another along that same line, another question, and this is regarding a non-patient. Um, Actually, I think it is a patient, but it says if the patient is in the office intoxicated, is there a duty? If so, what? Um,
So an ER, if you're an ER doc, yes, and it's an emergency situation, yes. Uh, you know, if you're a family practice doc and they're intoxicated and need emergency help, then I think you call 911. I think that's fine. So an intoxicated person in a non-ER setting for a non-emergency problem, I don't see any duty for you to that requires you to do that. I mean, uh, I'm there for a sore throat. They're drunk. I don't know. I guess every circumstance is different. Again, you'll be held to a reasonableness standard. Is it reasonable for you to uh, turn them away? You know, that's what ERs are for, intoxicated or not. They're for emergency situations. If someone's intoxicated and comes in just for a general checkup, I don't think you have any duty to take care of that patient. You say come back when you're not drunk.
okay, and and I think a lot of times if the patient comes in and they are intoxicated, I think that's an opportune time for the physician to talk to them about their any sort of alcohol abuse issues that might be happening and those types of things as well.
Well, that's certainly true. You wouldn't want to send someone home and then they die of alcohol intoxication. So um, if that's what they're seeking care for, and you're able to provide it. But if it's an emergency situation and you're not an emergency doctor, I guess you call 911. I mean, I, my guess is you don't have the workup ability to treat a drunk patient who might be toxic. I don't know. I guess every fact's different. You'll be held to a reasonableness standard.
Okay, and I think this is our last question, the last question that we're going to have time for because we are over the time limit. And he says, state licensing boards may request peer review minutes performed in the hospital when investigating a staff physician. Steve, do you believe that to be true? And if so, what are some of the protections that you can do?
So I would fight that like crazy if I was representing a hospital and the state DOPL was trying to get those minutes, because the policy is people won't be blunt if they're not, they won't be truthful and blunt if they're worried about this getting out. So the general rule is they're non-discoverable. I'm trying to think if I know of a DOPL exception, and I don't know of one. I guess I'd have to look at the specific wording of the statute, but I can tell you I would fight that as a defense lawyer, production of that, because it seems to fit in the policy. Now, I'm trying to think of, like, let's say you have a drug addicted doctor who's operating, and we're going to pull his or her privileges. Could DOPL get into those documents? I would certainly fight that they could not, but
Okay.
I can't say what every judge will do.
All right, and with that, we do need to sign off because, as I stated, we are over our time limit. But I do want to thank you very much, Mr. Steve Owens, for doing our presentation today. And again, I want to remind you that we will be back for our Lunch and Learn on Wednesday, March 21st, and that will be on telemedicine/telehealth. And we hope that you join us virtually for that as well. Thank you so much.
Thank you. Have a nice day.